Hey, I'm Nancy Cavey, National ERISA and Individual Disability Attorney. Welcome to Winning Isn't Easy. Before we get started, I've got to give you a legal disclaimer. This podcast isn't legal advice, but I will tell you that nothing will prevent me from giving you an easy-to-understand overview of the disability insurance world, the games that disability carriers play, and what you need to know to get the disability benefits you deserve. So off we go. This episode's topic is UNUM, and UNUM, much like other disability carriers, has a history of arbitrarily denying disability claims. If you've got a policy through UNUM, this is the episode for you, because this will give you insight as to the games that UNUM will play with various types of claims. I'm going to be telling you about 4 stories that I think illustrate the games that UNUM play. But if you don't have a UNUM disability policy, don't tune out. These are also games that other disability carriers will play. It's in the Disability Carrier Denial Handbook. First, I'm going to start with talking about the 5 reasons that UNUM used to justify denying a long-term disability claim by an emergency room physician with breast cancer. Second, I'm going to talk about how the lack of diagnosis and the ability to work in other medical facilities doomed an urgent care physician's claim for UNUM disability benefits based on multiple chemical sensitivity. Thirdly, I'm going to talk about a vertebral compression fracture and wedging claim that was denied by UNUM and ultimately overturned by a federal judge. And last, I'm going to talk about UNUM's claim that a policyholder's back pain was out of proportion to evidence of radiculopathy on exam was reversed by a federal judge. Let's take a break for a moment before we get into this exciting episode about UNUM. Welcome back to Winning Isn't Easy. Let's talk about another defense tactic, if you will. It's a tactic that disability carriers like UNUM will use from their toolbox. And it's the argument that your back pain or whatever pain you have is out of proportion to the medical evidence. And in this case, we're going to talk about a UNUM claim that an argument that the policyholder's back pain was out of proportion to the evidence of radiculopathy on examination. Now, that's the common sort of they're out of proportion, exaggerating their symptoms and functionality type argument. Many times, disability carriers will get away with this argument because the disability plan or policy has a get out of jail free card that grants the administrator or the carrier the discretion to determine whether or not you're disabled. It can be extremely hard to legally prove that a disability carrier has abused their discretion in denying a claim. And as a result, this get out of jail free card, this arbitrary and capricious standard of review, is used to not only justify a denial, but to convince the court that the court shouldn't and can't reverse the denial. Now, that's not necessarily the case if the applicable standard of review is what's called a de novo standard of review. That's the best standard of review you can get. And that means that the federal judge can substitute their judgment for that of the disability carrier. So let me tell you what happened in the case of Chico versus First UNUM. This is a New York case. Ms. Chico was a tax accountant, and in 2013, she started to have fatigue, weakness, and body pains. Her diagnosis from her doctors was fibromyalgia and radiculopathy. She tried all sorts of treatment and she attempted to return to work. But by 2019, she just couldn't do it anymore. So she stopped work and she applied for disability benefits. UNUM reached into their denial toolbox and said, okay, her reported pain is out of proportion to the evidence of radiculopathy on examination, and we think she can work. Therefore, we're denying the claim. They even suggested that if she was in so much pain, as she claimed, her treatment would be more extensive and her abilities at home would be more limited. Well, fortunately for her, the judge was able to apply the de novo standard of review. The judge looked at the medical records, looked at her reports of her activity, and said, look, the subjective and the objective medical evidence support her claim. Her treating physicians think she's disabled. And of course, the judge noted that every one of UNUM's liar for hire doctors who had never examined her discounted all of the relevant medical records. The judge said, oh, no. And basically said, "You are wrong, UNUM. You got to pay these disability benefits." And that was a great win for Ms. Chico. You need to understand that disability carriers have lots of tools in their toolbox to deny a claim. And if the carrier, like UNUM, says, "Hey, the physical findings are out of proportion," I'm sorry, your pain is out of proportion to the physical exam findings, then it's time for you to, in my view, hire an experienced ERISA disability attorney. The attorney should be reviewing your medical records to see what the report of your difficulties were to your physician and what you reported on your activity of daily living. Your attorney should be looking at the exam findings. And if those exam findings are minimal, consider getting what's called a functional capacity evaluation to objectively measure how your pain impacts your ability to function. We want to get out of the weeds by arguing that the issue is how the pain impacts functionality, not whether or not it's out of proportion to the evidence of radiculopathy or other findings on exam. And I think that's important because the severity of findings on examination are not consistent generally with the level of functionality. People experience pain in different ways. Some people will muscle through the pain, some people won't muscle through the pain, but I think all of that's relevant. And if necessary, you should consider getting your own independent medical evaluation by a consultant who can evaluate the physical findings on exam, conduct their own findings, take apart the disability carrier liar for hire peer review analysis of your medical records, and endorse the functional capacity evaluation. You can see there's a lot of work that goes into filing a disability claim and certainly overcoming a wrongful claims denial in the appeal process. I hope you've enjoyed this week's episode of Winning Isn't Easy. If you've enjoyed this episode, please consider liking our page, leaving a review, or sharing it with your friends. And I would love it if you subscribe to this podcast. By the way, I want to let you know that our 2022 Cavey Law Scholarship is up and running. We're taking entries until August. I want you to head over to caveylaw.com/scholarships to enter because we want to support people in their educational efforts. I hope you tune in next week for another insightful episode of Winning Isn't Easy.